Hi, I'm Adam Friedman. This is Senior Appellate Counsel at Friedman Bartolo, Stephen Vargas. Steve, how's it going?
Great, nice to be here again.
So first off, this is the second edition of the Weekly Friedman. I want to thank everybody for joining us last week. All of your comments and likes were very important. If you have any suggestions or thoughts for future videos, please leave it in the comments below. So today we'll be discussing U.S. Bank v. Narain. The litigating Friedman Bartolo attorney was Ron Lebeck. This is an Appellate Division, First Department decision stating that a mortgage reinstatement is a deacceleration of the debt. So first I'll give a brief recap, okay? So 2007, there's an action commenced that ends in a full reinstatement, and the case is then discontinued or dismissed, right? We have a later case, a few years later, 2013, and then eventually our action is commenced in 2014. The decision we're discussing today is an appeal of our successful summary judgment motion and the defendant's unsuccessful cross motion. Everything make sense so far?
Yeah.
So Steve, before I jump into everything, just define for our audience, because it's an important word for today, what we mean by acceleration.
Acceleration is defined as demand for immediate payment in full by the lender. And in New York, across the state, the courts have concluded the filing of a foreclosure complaint is a valid acceleration of a mortgage under virtually all circumstances.
Okay, so you said, remind me of acceleration again. What did you say again?
A demand for immediate payment in full.
Okay, so we'll dumb this down, okay? In 2007, right, as with any foreclosure action, plaintiff is demanding to be paid in full.
They did.
Right? In 2007, in response to being demanded to be paid in full, right, the borrower defendant reinstates the loan.
Correct.
As they were permitted to do. So they cure the default.
In 2008, the borrower cured the default in full, and there was actually an adjudication in the 2007 foreclosure that the borrower cured the default by reinstatement.
Okay, and then 7 years later, right, they're arguing that the loan had never been deaccelerated.
Correct.
Meaning
Correct.
the lender was still calling their debt due even though they had reinstated and cured the
Correct.
default.
Disingenuous, self-serving, both true. However, that's the argument they relied on to try to deem the 2014 foreclosure time barred.
It seems so obvious though. Like, how is this not on the books? Like, how is this declaration, right, that a mortgage reinstatement, or reinstatement of the debt, is not the acceleration?
It's certainly intuitive, and the vast majority of attorneys would agree with you, and would agree with the plaintiff in this position. The successful argument, the appellate court agreed, and that's what matters in this case. But as you can see in the decision, there are very few decisions on point. The appellate division had to cite decisions from 20 years ago to reach the conclusion it reached. And due to the scarcity of decisions on point, holding the borrower's unilateral act of curing the default by paying the full reinstatement was a valid deceleration of the mortgage. This decision is important because it's the first one in the First Department in many years in which the appellate court reached this conclusion.
Okay. Thanks a lot, Steve. Again, for everybody watching, please leave comments, suggestions. Let us know what you want to hear. We're always looking for new ideas, new cases, so please let us know in the comments below. Thanks again, Steve, and